Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we will unpack the Department of Justice's Civil CyberFraud Initiative that was announced back in October 2021. We'll explore how DOJ intends to leverage its enforcement authority under the False Claims Act to advance this initiative. And we'll also discuss what this initiative means for potential defendants. Hello and welcome. I'm your host, Bonnie Odom. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Los Angeles office. DOJ has wasted little time in mobilizing under its Civil CyberFraud Initiative and announced its first settlement under the initiative on March 8th, 2022. The case involved global medical services provider Comprehensive Health Services LLC, or CHS as we'll refer to it. And this is a Florida company that was contracted to provide certain medical support services to government-run facilities in the Middle East. And the government alleged that CHS violated the False Claims Act by falsely representing to the government that it had complied with certain contract requirements at these facilities. In particular, the government alleged, among other issues, that CHS had failed to disclose that it did not consistently store patient medical records on a secure electronic medical record or EMR system. CHS has agreed to pay $930,000 to resolve these allegations. On today's show, we're going to step back a bit and talk about what the DOJ Civil CyberFraud Initiative is intended to do, how the False Claims Act will be leveraged under the initiative, and what companies can do to mitigate risk in light of the initiative. We'll also consider whether the initiative makes practical sense and explore some potential unintended consequences. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. And for more detail on today's topic, please check out the article that was recently authored by today's guests. That's entitled DOJ's Civil CyberFraud Initiative, What Contractors Need to Know About Novel Use of the False Claims Act. And we'll include their email addresses in the show notes. Joining our discussion today is Stuart Gerson. Stuart is a member of the firm at EBG in our DC office. Stuart was the acting attorney general of the US during the early Clinton administration after having served as President George H.W. Bush's appointee as Assistant Attorney General for the DOJ Civil Division. He has focused his practice on fraud and cybersecurity issues. Welcome to the show, Stuart.
Hi, how are you today? Thank you for asking me to be on.
Of course, happy to have you. Also joining our discussion today is Alaap Shah. Alaap is also a member of the firm at EBG in our DC office. He previously served as senior counsel and chief privacy and security officer at Oncology Membership Society. And now he focuses on defense and counseling of healthcare entities and legal and regulatory compliance issues around privacy, cybersecurity, and data asset management. Thank you for joining us today, Alaap.
Thanks, Bonnie. It's a pleasure and honor to join the podcast with you and Stuart. This is such a timely and interesting development, yet it presents some very thorny policy and enforcement issues, which should make for an interesting discussion.
Great. Yeah, let's get into those. Let's start off with a brief discussion about what the DOJ Civil CyberFraud Initiative is and what it's intended to do. In plain terms, through the initiative, DOJ is looking to punish companies that place government information or systems at risk of cyber threats. For example, a company may be subject to scrutiny if it fails to implement adequate cybersecurity protocols or fails to inform DOJ when cybercrimes do occur. Essentially, DOJ intends to use the law, here the law being the False Claims Act, to get government contractors, including healthcare providers participating in federal healthcare programs like Medicare and Medicaid, to adhere to better cybersecurity practices. Alaap, can you speak a bit more to the motivation behind the initiative and specifically why healthcare providers and healthcare companies should be paying close attention to it?
Sure. Yeah, it's no surprise that cybersecurity has really come to the forefront of Americans' minds and public policy. This really is a result of ever-growing cyber threats that impact the public sector and the private sector alike, as well as individuals themselves. Unless you've been living under a rock over the past few years, cybersecurity breaches are increasingly becoming front-page news. Most recently, ransomware has been a preferred hacking vector, which has led to multi-million-dollar extortion schemes. It's crippled critical infrastructure, such as the Northeastern oil pipeline. It's even shut down operations at large hospitals, among lots of other impacts. So we're seeing, cyber attacks rise. We're even seeing them in the context of warfare, as evidenced by this Russia-Ukraine conflict that's ongoing. In light of these developments, the Biden administration spearheaded the federal government's policy push on cybersecurity. And chiefly, this was to combat and deter rampant cybercrime. Much of this crime being perpetrated by state or state-sponsored hackers. So as part of that push, the Department of Justice launched this civil cyber fraud initiative. The initiative essentially seeks, as you said earlier, Bonnie, to apply DOJ's False Claims Act authority to pursue cybersecurity-related fraud involving government contractors and grantees. But to be clear, this is not something new. DOJ has used its enforcement authority in cybersecurity context previously, and there are a number of other federal government agencies that are vested in promoting strong cybersecurity. Typically, it's been done in more of like a proactive technical assistance kind of posture rather than an enforcement posture, but we're seeing that change. And DOJ has definitely come out being much more aggressive in its enforcement. This, of course, is of particular concern to healthcare institutions that participate in federal healthcare programs like Medicare and Medicaid. Historically, we've seen DOJ use the FCA as a cudgel to extract large penalties for fraudsters that defraud the Medicare and Medicaid program. So healthcare companies always have a target on their backs. And now the FCA is being used in a somewhat novel way to expand DOJ's authority to look at cybersecurity. So I think it's going to become an acute concern for healthcare companies for that reason alone, but also for the fact that healthcare companies have historically been pretty bad at cybersecurity and have had a target on their back from a third-party hacking perspective for that reason. So now these healthcare companies are going to suffer the pain of looming cybersecurity threats from third parties, as well as follow-on investigations and enforcement by DOJ potentially. That's something that people need to be focused on, and it's another impetus for healthcare entities to take cybersecurity seriously from both a proactive and reactive standpoint.
Absolutely. And Stuart, Alaap had mentioned the government's use of the FCA in a novel way. Can you walk us through the basis for enforcement here?
Yeah, thank you, Bonnie. I can indeed. Before I get into the weeds, though, let me point out something, which is this is unique in the area of government enforcement, because the people who are victims, and the companies and entities that are victims of data breaches, of cybersecurity incidents, are, for a significant percentage of the time, victims of crime. And here is an incident where the government is pursuing a punitive policy against companies and individuals who've already been punished because they are victims, because they've been penetrated, most often in large cases, particularly ransomware cases, by state-sponsored or state-protected entities in countries like the People's Republic of China, Russia, Iran, and North Korea. So there is something unique about this. There's nothing unique about the False Claims Act. It dates back to the Civil War. While up to now we've spoken about this in terms of government policy and what the Department of Justice is going to do, under the False Claims Act, a distinct minority of cases are originated by the government itself. As is well known, the False Claims Act allows individuals to sue in the name of the government. They're called quitam relators. 80% of the cases that they bring get washed out, but they impose a very high cost. And in this area, cybersecurity, they run into the multifarious tasks that government is doing. Agencies like the Securities Exchange Commission, the Federal Trade Commission, the Federal Communications Commission, all are promulgating regulatory cybersecurity policies that deal with breach cases, that deal with cybersecurity. All of this magnifies the importance of compliance. Now, to get to the False Claims Act, the False Claims Act subjects to potential treble damages judgments individuals or entities that submit or cause others to submit false claims for payment to the United States, or to withhold key information that allows the government improperly to make payments to those individuals. As I said, most cases are brought by quitam relators. And the reason why that's so is, like Willie Sutton said when asked why he robbed banks, that's where the money is, that relators can get a substantial share of any recoveries that the government has. And most often they're unsuccessful. I mean, most of the big False Claims Act cases are ones in which the government either originates or more likely intervenes. The rest of them tend to fall by the wayside, so that the False Claims Act operates significantly as a wealth transfer vehicle. But what happens when an individual relator raises a claim? There's a couple of month period where the government investigates the claim, decides whether to intervene or not, and the case proceeds either with the government, or if the relator attempts to without the government being present. Here is an area of cybersecurity where, at least in theory, the government has been around for a while. But again, because as Alaap astutely pointed out, there's so much activity in this area. One is less concerned with what the government itself is going to do, because the government has a whole variety of tasks. As for example, the criminal division and the deputy attorney general are talking about this enforcement policy that you've highlighted, Bonnie. The FBI is looking for cooperation and is attempting to get written into legislation that provides safe harbors, an enhanced role for the FBI. So the government has often contradictory aims here. And while that's problematic in some regards, I think one can count on the government for good judgment in the sort of cases that it's going to proceed with. That's not to say that that's going to deter private relators and their fee-seeking counsel from pursuing cases like this. What's the theory? Well, as you've pointed out in the notes to this proceeding, and we can amplify, the government's theory in this case rests on false certification. Most contracts that individuals have with the government don't contain cybersecurity related clauses, although increasingly that's going to be the case. So where there's a violation of something like that, you can have a direct false certification theory in fact. But in addition to that, and the Supreme Court has upheld this, the government often proceeds, and relators in the name of the government often proceed on an implied certification theory, which is that if there's an assertion that all relevant regulations and statutes have been complied with, violating one or another means that you've attempted to gain or have gained compensation falsely within the terms of the False Claims Act. It's an interesting point with regard to cybersecurity, because exactly what is it that's being certified directly or impliedly? What is it that the government can point to? In the government contracting area, we now have an executive order that the president has issued that binds government contract entities to certain compliance norms, and that's going to be argued in future cases. But there's no particular statute that calls out specific means of cybersecurity compliance. We know what the Office of Foreign Asset Control at the Treasury Department has had to say about dealing with ransomware criminals. We know what the National Institute of Standards and Technology has had to say, and other agencies of government with regard to creation of standards. But there's a lot of vagueness in this. And so as someone who defends companies, I expect that we're going to be able to argue that there are not clear standards. What we really hope for, though, is the emergence of federal legislation that will clarify what compliance responsibilities are, offer effective safe harbors, and preempt the 50 state and all territory individual data breach and data security laws that often conflict with each other. So that's the broad tapestry.
Alaap, with that false certification theory and the rest of the backdrop that Stuart presented in mind, if we go back for a minute to the recent CHS settlement, can you explain DOJ's allegations and give us a little more color on where CHS went wrong in that case?
The starting point is that, ironically, there was no breach in this case. Typically we would see a data breach and all the sort of fallout from that, including government inquiry. Here, there was no breach. In fact, it was a qui tam related issue where there were some insiders who had complained or alleged that CHS was not complying with good cybersecurity practices vis-a-vis its saving of patient medical records on a server that was not the secure medical record system. Here, we have a clear signal, a strong signal from DOJ that's saying, we don't care if there's a breach or not. We're still going to scrutinize your cybersecurity practices pre-breach. So clearly they're trying to send a message from the mountaintop. The qui tam relators in this case, they basically said that CHS contractually agreed to use a secure patient electronic health record system, which the government did pay for, to exclusively store all the patient medical records. But in fact, CHS failed to do so because it was using its personnel to scan records and then store those records in an unsecured network drive that pretty much anyone had access to based on the complaint. And then further, the relators said that they had raised these issues internally to CHS, but CHS essentially ignored those complaints. So what that really translates to, from my lens as a healthcare entity being subject to HIPAA, the Health Insurance Portability and Accountability Act, the allegations essentially translate to likely a lack of adequate controls related to a few areas. Probably role-based access control was not in place. They did not have robust authentication, passwords, et cetera, that were required to get access to these separately stored files. Encryption was likely an issue. There's probably no encryption in that file share. Auditing capabilities were probably not there. You wouldn't know who touched these things or opened them or looked at them. And then they probably had inadequate administrative controls relative to training their personnel, as well as likely a lack of documented policies and procedures, because it's evidenced by these allegations that people were storing these files in places they should not otherwise be storing them. So that's sort of, as Stuart pointed out earlier, there are standards. There's HIPAA standards, and this is what CHS was being measured by. But the real challenge with the DOJ's approach here is that their basis is a fraud allegation about failure to comply with these contractual requirements. But it treats cybersecurity as a binary thing. Yes, you are secure, or no, you are not secure. And that's a false proposition. There's no such thing as 100% security. As Stuart pointed out, it's a sort of squishy, evolving concept. Cybersecurity controls evolve constantly, just as much as cyber threats are evolving. There are even scenarios where cybersecurity controls don't even exist yet, even though a threat does. And those are called zero-day exploits. And again, as Stuart pointed out, there's a great deal of flexibility under our existing laws about what could be a reasonable cybersecurity practice based on the size and scope of your organization. So for DOJ to use this approach and say, yes, you are secure, or no, you're not secure, it seems like an inadequate approach to dealing with this issue. So,
Alaap, excuse me, there's an interesting irony to all of this, Bonnie, which is that the GAO, the Government Accountability Office, conducts annual surveys of government agencies with respect to cybersecurity. And virtually all of them fail all of the time in meeting the standards that the government sets for itself. The point that Alaap just emphasized is a really valid point. But I'll note something else just in passing. I mentioned how the government or a relator in the name of the government might pursue an implied certification theory. That's not the case in the settlement that you premised this discussion on, or that Alaap was just speaking about. There's a breach of contract where at least there were some specific terms laid out with which the subject company failed to comply under any standard. We'll get back and talk about compliance, and we can talk about zero trust and where companies ought to go, particularly in healthcare. But I did want to make that additional point.
Yeah, thanks, Stuart. And I'll just wrap up by saying that what this basically means is that there's likely going to be cases where very well-intentioned companies will invest in cybersecurity and still face a breach, or still have someone complain that there's cybersecurity weaknesses. And then the company is going to face scrutiny by DOJ under this approach. And even if they've operated in good faith, they're going to have to go through potential allegations and defense in the context of this False Claims Act enforcement. So really what we need to be thinking about is proactively how should companies be posturing themselves to thwart this kind of allegation early and showcase their cybersecurity quickly if there is some sort of inquiry.
Yeah, agreed. And building on how companies can build up protection for themselves, Stuart, you had mentioned that there's certainly some vagueness in cybersecurity standards. And what are some sources for companies to look towards with regard to shaping their cybersecurity programs?
The answer to that question is one can look almost everywhere, because there are cybersecurity tools that virtually every security agency is issuing, and the private sector as well, through interest organizations, is doing the same thing. And standards are actively being considered as far as statutory matters on Capitol Hill as we speak, and something is likely to pass. But a good starting point is in the publications of NIST, the National Institute of Standards and Technology, which has published toolkits that companies can rely on. Alaap mentioned earlier that the Department of Health and Human Services, Office for Civil Rights, which is the action agency for cybersecurity under HIPAA and related statutes, is another place. CISA, that part of the Department of Homeland Security, and in conjunction with the FBI, has issued a series of standards. So there are lots of places to look. The question that both Alaap and I have posed is, okay, well, there are lots of different standards. There's a great deal of similarity among them. It's a lot like airlines in third world countries. Every agency's got to have one. So one can look to standards. If there's, to me, a theme that ought to be pursued, it's something I mentioned a little earlier, and that's the concept of zero trust. That's just what it sounds like. In shorthand, it means that every data-seeking transaction, even internally, should be treated both technologically and personally as something coming from a hostile source. Alaap mentioned one thing that is paramount, which is control of access to systems and limited permissions. You add to that common mistakes that are made within entities concerning patching and updating of software, adequately vetting vendors, cloud providers, testing open source related software, which many applications are being used in the private sector and which we learned recently are attackable. At the end of the day, most problems are problems caused by individuals. And so another part of zero trust or any policy is adequate training and testing of your individuals, particularly with regard to emails of a phishing or spear phishing nature. And still, there are going to be many mistakes. And so you have to develop resilience. If you become subject, or at least the potentiality of being subject to a ransomware exploit, can you get back on your feet without paying the ransom? What can you do in the short term? How do you protect data against exfiltration, where cyber bandits will resell your information to third parties? This has become a policy, by the way, of the People's Liberation Army of the People's Republic of China as a way to gain economic leverage over the United States. These are important questions, and those are just a few hints. People like Alaap and I spend a lot of our time counseling companies and other entities about how to preserve data, how to take care of things. But they've got to act on it. They've got to train, they've got to test, and they've got to pursue policies that are rigid ones. Tabletop exercises are another example of where to go and things like this, so that you know how to be prepared for the inevitability that you're going to be hacked by somebody.
Yeah, Stuart, you raise a number of good prevention strategies for companies to consider. Alaap, let's think about a company where it might be too late for prevention. So let's think about a company that has had one of these False Claims Act lawsuits brought against it related to cybersecurity issues. What are some defense strategies that company might want to think about?
I like to say it's never too late. I think cybersecurity is an ongoing endeavor. It's a journey, not a destination. But I will say that defense after a complaint's been filed is always tough. The company is really going to be evaluated based on the period of time where the alleged fraud occurred. So in other words, don't all of a sudden try to adopt policies and procedures and controls and try to get retroactive credit for those things. But with that said, I think there are a few things to always keep in mind when you're facing this kind of lawsuit. You always have a better chance of success if you cooperate fully with the DOJ in its inquiries, including any kind of civil investigative demands or other touches. As we saw from the CHS allegations, going back to that case, DOJ really didn't like the fact that CHS sort of buried its head in the sand when it came to some of the complaints raised internally. A similar theme would apply in the context of dealing with DOJ directly. Just don't bury your head in the sand. Face these issues head on and do so in good faith. You should also work on putting your best foot forward to showcase what cybersecurity you do have. A lot of times it's squishy, like I said earlier, and Stuart pointed out as well. There's wiggle room to make a case that what you're doing is reasonable given the size and scope and nature of your company. So go ahead. Dig deep, find the documentation you can and evidence base you can to show that people are doing the right thing, or at least trying in good faith to do the right thing. I think it'll soften any kind of enforcement. If you're regulated by another agency, just like healthcare companies would be, Stuart mentioned the HHS Office for Civil Rights, who enforces HIPAA. If you're regulated by an entity like that, you should try to showcase how you comply with that set of standards. Show that you have a cybersecurity program that meets HIPAA standards and that you have documented policies and procedures and that you're measuring risk and doing risk management activities. These kinds of things show that you're following the rules as prescribed. And so DOJ should not take a contrary position to what that primary agency is doing. And of course, if you're a victim of cybercrime, which many of these scenarios are going to involve some sort of third-party hacking criminal, if that was the cause of a breach that you suffered, make sure you make that case early to the DOJ that you're a victim and that you're cooperating with law enforcement on these issues. Maybe even seek DOJ support in the context of that if it's appropriate, because I think there's a lot to be said to that policy position that Stuart raised earlier, which is DOJ shouldn't be in the business of victimizing people who are already victims. It's just really a bad position for DOJ to take over time. These are ways to posture yourself to soften any kind of enforcement action. I'll defer, though, to Stuart, who's worked inside the hallowed halls of DOJ to really speak to what goes on in terms of whether DOJ might intervene or decline a case.
Well, I think, Alaap, you make a very good point about trying to mobilize the forces of good to help you along with your discussions with the Department of Justice. I think that DOJ will act reasonably in most cases. And as I said earlier, I think the nuisance factor of relators that continue on absent the government is because companies are so quick to settle cases, particularly public companies are so quick to settle cases to avoid bad publicity and to get them off their books. In dealing with DOJ, remember there's another part of DOJ that's begging for cooperation. That's the Federal Bureau of Investigation. If you suffer a breach, contacting the regional office of the FBI and its cyber divisions are important things to do, and try to mobilize another part of DOJ to help you as against the civil and criminal divisions, which are pursuing the policy that Deputy Attorney General Lisa Monaco laid out in the first place.
And as we look ahead, there doesn't really seem to be any indication that DOJ intends to pull back on this cyber fraud initiative, but there remains this sort of fundamental question, which Stuart and Alaap have raised, about whether the initiative makes sense and whether there might be certain unintended consequences. One concern is that the initiative creates a disincentive for private companies to partner and work with the government to protect national security interests. Stuart, can you speak to that a little bit more and about how the initiative might prompt this disincentive?
Well, I think you've stated it pretty succinctly, Bonnie, but to amplify on that is the government is begging for public-private cooperation. The head of CISA, that part of the Department of Homeland Security that deals with cybersecurity and outside threats, the director of that has made it very clear. She has literally begged for public cooperation. Other agencies of government have done the same thing. Look, we are parties, or at least third parties, to a cyber war that is now going on with the Russian occupation or attempted occupying Ukraine. We're facing ongoing issues like Russian interference in our elections, like Chinese interference in our economy and theft of intellectual property, like activities of other hostile states like North Korea with regard to Sony Pictures. Several months ago, the United States experienced the negative effects of a ransomware attack on Colonial Pipeline, which held up East Coast transshipment of gasoline and other petroleum products for the better part of a week. If you can imagine hospitals being closed down at a time of national peril, or the power grid being shut down, you know that we have pronounced national security issues where the government, which in and of itself can't solve a lot of these problems. 80% of the critical infrastructure is owned by private entities. And that's true of virtually everything that is involved in the business of healthcare, which we've talked about a little bit periodically through this discussion. So there are tremendous national security interests that are at play here. And if there is a policy that forces businesses to clam up because they're worried about being sued or even worse, being prosecuted, what's the incentive going to be? It's going to be a disincentive. And that's something that has to be balanced. It's something the government has to come to grips with. This is a field, the overall field of cybersecurity law is something where we are in need of harmonization and the creation of particularly in the United States, of a national standard. And if you want to get cooperation, there ought to be safe harbors in conjunction with that standard. There are safe harbors in other areas of fraud under the anti-kickback statute, for example, if we want to talk again about healthcare. We're in if not the earliest stages of the evolution of the law regarding cybersecurity. We're still enmeshed in process, and there's a need to unify our approaches. There are people who are actively pursuing this in the legislature. Senator Mark Warner comes immediately to mind as one of the congressional leaders in trying to get national preemptive data breach legislation passed, where industry through the National Chamber of Commerce and others are supportive of these activities if they have reasonable incentives that are aligned with them. And so the False Claims Act environment is only a sub portion of the overall cybersecurity threat, which is a national and international threat. And so we're going to continue to see developments here, whether this mostly stick and very little carrot approach that DOJ has announced is going to be beneficial. Only time will tell. What we can say with certainty is, particularly through the force of quitam relators, there's going to be an increase in claims that are being brought. There's going to be an increasing time and expense that subject companies and institutions are going to face, and a need to get ahead of the game with enhanced compliance, perhaps following the zero trust model.
Yeah, absolutely. And Alaap, before we close out for the day, I wanted to raise one other nuance that we see here. So unlike a typical data breach case and these False Claims Act cases, the government does not need to show that it suffered an economic injury to prevail. Can you talk about what this concern means and if there's anything DOJ could do to narrow the focus of the initiative to address this concern?
Yeah, it's just the disconnect between DOJ's authority and what the courts have done in the context of data breach. I mean, a key ingredient when it comes to seeking restitution for something like a data breach is typically when someone's been harmed. There's been data lost, data stolen and misused, and now plaintiffs are alleging that they are suffering from identity theft or financial fraud. But that's not how DOJ's authority works. So the question really becomes, how do we really quantify the amount of damages that should be available in an FCA case? In fact, a lot of courts throw out cases altogether because there's no injury in fact that's provable. But the DOJ's case would continue on under the FCA. I guess the real question, a policy question, is should DOJ use its enforcement discretion in a manner that better aligns with how courts have been dealing with this issue? Should they only pursue cases where there's actual individual harm that's alleged and where the cybersecurity related fraud is actually egregious in nature? Because anything short of that puts us in a position where DOJ is enforcing against companies that are acting in good faith where there's likely no injury at all, which just doesn't seem to be in line with what our experience has been in the way that our laws have currently treated data breach scenarios.
That's a very good point, Alaap. I note a couple of things. The penalties provisions of the False Claims Act provide for treble damages, which presumes some economic injury or impact, but also statutory penalties. And those were designed to deal with attempts where monies weren't obtained. And I note that the government is in the process of increasing the individual penalty amount to now more than $22,000 per offense. They would seem, at least logically, to be that the statutory penalties would seem to be illogical when applied to data breach cases. And again, I expect that the government will act responsibly in accordance with that, but you're still going to get some colossal damages demands based on the threat of treble damages. That's something to consider. A legal point that Alaap has put on the table, though not overtly, and I want to expand upon, is the federal circuits, the Circuit Court of Appeals, are largely divided on the question of standing. Alaap mentioned that courts often throw out cases where there's no indicia of harm. And that's not because the False Claims Act doesn't theoretically apply. It's because the individuals who are attempting to raise these claims don't have standing. They haven't suffered any injury. And so they don't qualify under Article 3 to be able to bring a federal case. I myself have been involved in this, and companies are very interested in getting the Supreme Court ultimately to clarify the Escobar decision. With regard to standing, one hopes, at least from the defense side, to prohibit bringing cybersecurity data breach cases under the False Claims Act or otherwise, where there is no demonstrable injury and all that plaintiffs are alleging is fear of future injury. You hear about identity theft all of the time. Identity theft is certainly profound for people who experience it, but it's relatively rare. While identity theft is important, it's much less important than national security. It's much less important in a whole host of other things. And where it hasn't occurred, to allow standing simply because you're afraid that it might is probably a bridge too far, at least as far as the defense side is concerned. And so this is a question, again, that at least the defense side hopes will be answered effectively by the Supreme Court. On the other hand, the court's had several opportunities to do this and has passed. So time will tell.
On that note, Alaap and Stuart, thank you again for joining the show today and sharing your insights. It was a pleasure to have you both here.
Thanks, Bonnie.
Thank you.
And thank you to all of our listeners. Don't forget to subscribe to the Diagnosing Health Care podcast, which is available wherever you get your podcasts. Also, as I mentioned before, if you'd like more detail on today's topic, please check out the article that was recently authored by today's guests, Stuart and Alaap. That's entitled DOJ's Civil Cyber Fraud Initiative: What Contractors Need to Know About Novel Use of False Claims Act. And we'll include their email addresses in the show notes.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.